2022 CR 2790 and 2022 CR 10495, State of Texas versus King.
Before we even get into the charges, listen carefully to this warning. When a judge opens a hearing talking about 25 years minimum, that's not a scare tactic, that's Texas law knocking at the door. Ask yourself, how fast can one bad decision turn into a lifetime label?
And Brown, do I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Arlene Gay for the defendant.
All right. And are you Mr. Brown?
No.
Counsel, have you received all the discovery in each case, and did you review it with your client?
Yes, all the cases we're pleading on, except for one notation I was told today.
Judge, so on cause number 2022 CR 2790, there was a audio file that was mentioned in the prosecution guide from one of the witnesses. I had reached out to SAPD because we did not have that in our possession. SAPD reached out and said that they didn't have it. They updated me today, and that's when I told defense about it.
It's the conversation is noted.
Yes.
It's just the recording. If there was one ever made, it was not, and they told me, and that's one of the cases he's taken a plea on today.
All right. And knowing that, do you still wish to continue with the plea?
Yes, Your Honor.
And Mr. Brown, do you still wish to continue with the plea? I got it.
Yes, ma'am.
And are there any applications?
No, Your Honor.
And each cause number, I'm going to show you the court will find that the state is in compliance with discovering each cause number. And in each cause number, Mr. Brown, I'm going to show you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State and the cause number ending in 10495. Are you proceeding on the indictment as presented?
Your Honor, I believe there's a repeat offender enhancement. We are not proceeding on that. We are waiving that. But otherwise, we're proceeding as presented.
Okay. Any objection?
No objection.
And in the cause number ending in 2790, state, are you proceeding on the indictment as presented?
Your Honor, the state is going to waive the repeat offender enhancement, but otherwise proceeding on the case as presented.
Any objection?
No objection.
Mr. Brown, in each cause number, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them, and did you sign them?
Yes, ma'am.
And the cause number ended in 2790, you're charged with the offense of aggravated assault with a deadly weapon. And the cause number ending in 10495, you're charged with the offense of robbery. Each of those offenses are second-degree felonies. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand? Did you understand by entering into these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane in each of the cause numbers?
Yes, he is.
Mr. Brown, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Mm.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial in each of the cause numbers. And each of the cause numbers, I'm showing you the plea bargain page. Did you review those with your attorney? Did you understand it?
Yes, ma'am.
In each of the cause numbers, punishment is to be assessed at 5 years in the prison. There are no applications. The cause numbers will run concurrently. The state will take in consideration 2022 CR 2791, 2023 CR 5662. This is to run concurrent with your federal case 22 CR 246. And did you understand that if the court finds that there was a deadly weapon in the aggravated assault with a deadly weapon, then the court will enter an affirmative finding of deadly weapon? Did you understand that? Did you understand that to be your plea bargain agreements in each of the cause numbers? Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
And each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there hasn't.
Then in cause number 2022 CR 410495, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2022 CR 2790, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's pleas.
State offers State's Exhibit 1 in both cases. It's different States Exhibit 1s.
No objection.
All right. In each cause number, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, we're just asking that the court follow the plea bargain, and I'd like to address the documentation of back time in this matter.
Okay. Then in cause number 2022 CR 10459, the court is finding you guilty. Court will follow your agreement, sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 2790. Take in consideration 2022 CR 2791 and 2023 CR 5662. This will run concurrent with federal cause number 22 CR 246. And counsel, you wanted to address the issue of back time?
Yes, Your Honor. I know there's probably some notes on your jacket that Mr. Brown was in federal custody. He was removed from Bexar County Jail in June of 2022. He was arrested. He was actually booked on 2/16/2022 here in Bexar County. He was here and then removed to federal custody and then returned from federal custody and has been incarcerated this entire time. I'm asking the court, knowing that that is what the court is aware of, that the court grants all time from 2/16/2022 to today, which is 1/16/2024, excuse me.
State,
Yes, Your Honor.
on the back time issue?
Judge, my understanding is that he would be entitled to that under at least.
No, I mean, have you done your research as well?
No, this is really the first we talked about it.
All right. You're an officer of the court, so you researched this and this is the time?
Yes, Your Honor, because was the delay in the case, was that he was in federal custody.
All right. So you say he's been in custody since 2/16/2022?
2022 until today, 1/16/2024.
And Judge, I will say that does sound correct. Again, the specifics on the federal custody, I don't want to say, but that does sound correct.
All right. So he'll be given custody from February 16th, 2022 till today. Is there anything else with regards to that case?
No, Your Honor.
All right. In that cause number, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Next, we're going to proceed with sentencing and 2022 CR 2790. The court will follow your agreement, sentence you to 5 years in the prison, give you credit from credit for any time served beginning February 16th, 2022 through today.
Yes, Your Honor.
There's an affirmative finding of a deadly weapon. This will run concurrent with 2022 CR 10495, the federal case 22 CR 246, take in consideration 2022 CR 2791, 2023 CR 5662. Is there anything else with regards to sentencing in that case?
No, Your Honor.
And in that cause number as well, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Mm.
All right, we can go off the record. How old are you?
34.
All right, you're 34. And it appears that you determined to spend a lot of time in custody. After this time, you need to sit at the jail, sit at the prison, and think about, why am I here? How did I get here? Do I really want to live my life? Institutionalized. Because if you do, what's going to end up happening is at some point, you're going to be labeled as a habitual offender. And in Texas, when you're a habitual offender, depending on the offense, your minimum starts at 25 years. Do you understand?
Yes, ma'am.
So you're going to have to change your ways. And if you have an anger issue, you need to work on it. All right. Good luck to you. You're welcome.
This might sound like a small detail, a missing audio file, but legally it matters. Discovery issues can derail cases. What's important here, the defense still chooses to move forward. Translation: they believe the plea deal is safer than rolling the dice at trial. This is one of the most misunderstood moments in court. A plea deal is not a promise. The judge can legally reject it, increase the sentence, or send the case to trial. When the defendant says yes ma'am here, he's betting his future on judicial discretion. And just like that, the switch flips. No jury. No witnesses. No dramatic objection. One sentence from the bench turns an accused man into a convicted felon. This is the quiet power of a plea-based justice system. That phrase, affirmative finding of a deadly weapon, is huge. It doesn't just affect this sentence, it impacts parole eligibility, prison classification, and future cases. This isn't extra time, it's extra weight that follows him long after release. This is Judge Boyd's final warning, not emotional, not loud, but devastatingly clear. At 34 years old, the court is asking a question the law can't answer for him. Does he change now, or does the system change him permanently? What do you think, fair sentence or too lenient?